So we need to talk about a recent 9-0 unanimous ruling that was issued by the Supreme Court involving the Fourth Amendment's protections and when excessive force by law enforcement impacts that right. The Fifth Circuit has now issued a new ruling in light of that decision, and they're potentially defying what the Supreme Court said, and this is already heading back to the Supreme Court. It's going to go to conference this Friday because of what the Fifth Circuit did. So let's break down what is happening in this critical case. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply by subscribing. You can also hit the like button that just tells the algorithm that you appreciate this content, and so it shares it with more people. Now, as I mentioned in the intro, in this video, we're going to be discussing a recent 9-0 unanimous ruling that was issued by the Supreme Court. This case involves the Fourth Amendment's protections against unreasonable searches and seizures, and when law enforcement activities through excessive force impact those rights. This unanimous ruling came in a case called Barnes versus Felix, and this case is already heading back to the Supreme Court for re-review just months after the court issued that ruling. And that is because the Fifth Circuit has issued a new ruling in light of what the Supreme Court said in that 9-0 decision. The Fifth Circuit has once again ruled that the officer's actions are protected even under the totality of the circumstances approach, and the en banc panel here denied review to the case, so that led for the plaintiffs here to go to the Supreme Court once again, ask for the Supreme Court to reevaluate what the Fifth Circuit did. And now this case is heading for consideration in the Supreme Court this Friday. Now, the facts around this case are as follows. Essentially, there was an officer, a law enforcement officer, who pulled over an individual, Ashton Barnes, for suspected toll violations in a rental car. Felix ordered Barnes to exit the vehicle. Barnes opened his door and acted as if he was going to exit the car, but then he attempted to drive away. Now, reacting in a split second, Officer Felix here decided to jump onto the ledge of the car as it drove away. He then fired 2 shots at Ashton Barnes as the car was driving away. Those struck him and he was fatally hit and wounded. Because of this incident, Barnes' mother sued the officer on her son's behalf, alleging that the officer violated Barnes' Fourth Amendment right against excessive force. Now, on review, the district court granted a summary judgment in favor of the officer, applying the Fifth Circuit's moment of threat rule. Now, the Court of Appeals essentially affirmed that as well, explaining that the moment of threat rule requires asking only whether an officer was in danger at the moment of the threat that resulted in his use of deadly force. Under the rule, events leading up to the shooting are not relevant and are not considered. Now, like I mentioned, this case went to the Supreme Court already, and on review, the Supreme Court issued a 9-0 unanimous ruling, striking down what the Fifth Circuit said. And the Supreme Court held that a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. They stated that the inquiry into the reasonableness of the officer's force requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to the incident. So in this case, the Supreme Court rejected the more limited moment of threat analysis that was used by the district court in the Fifth Circuit, and instead applied the totality of the circumstances approach. They stated that most notable here, the totality of the circumstances inquiry has no time limit. While the situation at the precise time of the shooting will often matter the most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. So the main thrust of the Supreme Court ruling was rejecting the more limited scope of analysis that was applied by using the moment of threat review, and instead the Supreme Court said you had to look at this incident and other ones using the totality of the circumstances. Now, after the Supreme Court issued that ruling to send the case back down to the Fifth Circuit to re-review the case, apply the correct totality of the circumstances approach, and issue a new ruling. Now, interestingly, the panel in the Fifth Circuit did not hold oral arguments or ask for additional briefs in light of what the Supreme Court said in that ruling. Instead, they just re-ruled on the case on their own without additional briefs or arguments. In the new ruling, the Fifth Circuit panel held that even under the totality of the circumstances approach, the officer's actions were warranted. The panel reasoned that any vehicle flight, any at all, creates a deadly threat, and that the officer here reasonably used lethal force to prevent a dangerous chase. Because of that quick new decision without additional arguments or briefs, Barnes's attorneys are now once again seeking Supreme Court review. They have filed for once again Supreme Court review, and in their petition they argue that this new ruling by the Fifth Circuit contradicts what the Supreme Court just said in that 9-0 decision. Now that this case is back in front of the Supreme Court seeking new review, things have been moving very fast. After the petition was filed, the government here actually filed a waiver of their right to respond to the petition, meaning that they are not planning to defend the case unless the Supreme Court specifically orders them to file that response. And as of right now, the Supreme Court has not requested a response. On top of that, the Supreme Court has already distributed this case to go to conference this Friday. So this is a very important signal for this case. Typically, when the Supreme Court is seriously considering a case, you will see the court request a response from the other side, even if they filed that waiver, and that will happen usually before the conference. That has not happened here. And that usually can suggest that the Supreme Court may not be leaning towards actually taking the case at this stage. And this is similar to what we saw just play out in a different case, a two-way case, which was the Peterson suppressor challenge. A very similar waiver, a lack of response being ordered, and a conference happened in that case as well. And that case was just denied. However, this case will still go to conference, and that means that the justices at least will consider what they want to do with this case and take a look at it. So now all of our eyes will be focused on what happens after Friday's conference. The court has a few options. They could deny the case outright on the next week's order list, which could be more common, especially when you see this type of waiver and lack of a response being ordered. They could relist the case for another conference, and that could signal that at least one of the Supreme Court justices is considering this case and wants to take a closer look. Or they could simply request a response after that conference, kind of ignore that waiver and say, after the conference, yes, we do want you to file a response. And then you would see this case get removed from conferences, and then they would start the additional briefing that would be required. So like I mentioned, all eyes will be on what happens after Friday's conference. So that's where things currently stand with this Barnes versus Felix case. You had that unanimous Supreme Court ruling. It went back to the Fifth Circuit. The Fifth Circuit, kind of just pushed the case once again, did not add additional arguments or briefs or anything like that, just ruled on their own. Used a different rationale to support the ruling because they did not like what the Supreme Court ordered them to do. So they just found a different way to uphold their prior decision. And now this case is once again back in front of the Supreme Court just months later, and it's heading to conference this Friday. So again, we'll see what happens. We'll see how this develops. As we get more information, as this unravels more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm. It just tells the algorithm that you appreciate this type of content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.